This is Richard Seller. We're talking a little bit today about FMLA and how that works in the workplace. And there's a lot of misconceptions about FMLA. It's a very important law, but it doesn't always apply to everybody. And I want to talk to you a little bit about who it applies to. Very briefly, I'm not going to get legal or technical on you, but I want to sort of explain the parameters. So the FMLA only applies to medium to large employers. And here's what I mean by that. In order to be covered by the FMLA, and FMLA stands for Family Medical Leave Act, okay? Forget about your health for a minute. You have to work for an employer that has 50 or more employees within 75 miles of where you work. So here's the thing. If they don't have that number of employees, no matter what the situation is, no matter how egregious it is, they don't qualify. They're not considered or required to adhere to that law. So we oftentimes see a situation where an employee needs medical leave, goes out, but the employer is not the FMLA covered size of having at least 50 or more employees within a 75-mile radius, and unfortunately there's nothing we can do. So that's really important. That's the first thing I'm going to tell you about FMLA, is your employer has to be approximately that size. If you've got questions, if you're not sure, email us. Err on the side of caution, and let's talk about whether we can find a way to get you covered. The other thing is you got to be a full-time employee who worked for the company for at least a year. Excuse me. So let's assume that the company's big enough, they have 50 or more employees within a 75-mile radius. You have to work for the company for at least 12 months, and during that 12 months, you have to work for at least 1,250 hours. It essentially comes to, I always forget the math, but if I do it here really quick on a calculator, it comes to about 27 hours a week, and that would qualify you if you work those 27 hours week in, week out for 52 weeks. And the math I did, you can check it, came to 24, but it's 1,250 hours in a year divided by 52, just to kind of give you a simple math. So real important, guys. We're here to help you. We want to help, but if you're not FMLA covered, if you don't have the 50 or more employees, or if you didn't work there for at least a year for 1,250 hours, the law is not going to apply to you. That doesn't mean you may not have a case. We can look for another avenue to pursue, such as perhaps on a disability discrimination type of case. So you're obviously here for a reason. Reach out to us, and we're happy to take a look. But let me say this to you. For clients who are covered by FMLA, these cases hit near and dear because when you're fired at a time when you need help the most, it's incredibly traumatic for our clients. And let me explain to you what I mean. FMLA covers serious health conditions for you or a family member. We see situations where we have an employee who, God forbid, gets diagnosed with cancer, and there's a fairly common fact pattern, tells the employer they're going to need to take time off from work. The employer, if they're an FMLA-covered employer, the employer is required to offer the employee FMLA leave for up to 12 weeks. And oftentimes you'll see that the employer either fails to on purpose or by accident, and then the employee goes out and ultimately gets fired, and that's illegal under the law. The employee needs to know about their FMLA rights. And we've got a case that we're handling right now, which we think is egregious, where the employee was diagnosed with cancer, notified the employer he's going to have to take time off for chemotherapy, and 3 weeks later he's fired under the nonsense reason that he wasn't performing well, although he had no prior incidents of discipline or any other action. So this is something we see all the time. Under the FMLA, if we prove that there's a violation, you're not only entitled to your back wages from the date of your termination through trial and possibly beyond, but like the overtime cases, you're also entitled to double or liquidated damages as a penalty for being treated or illegally or fired in your time of need. One of the biggest violations that we see under the FMLA is simply not advising employees of their rights. The employer has the burden, once it learns that the employee may need FMLA time off, to actually offer the employee FMLA forms to fill out and notice of their rights to leave. So if you work for somebody, or if you worked for somebody in the last 2 years and you needed to take time off from work, and again, assume they were FMLA covered, as were you, and they failed to offer you FMLA time and you were ultimately fired for, quote, taking too much time off from work, it's something you should definitely reach out and something we would take a look at. So FMLA covers, like I said, your own serious health condition, if you're hospitalized overnight and need time off from work. And as I indicated earlier, FMLA and disability, or what we call ADA, Americans with Disabilities Act claims, often overlap. So we generally take a look at both avenues when a prospective client contacts us and says, hey, I needed medical leave time off and I was fired. Let me tell you a quick story about an FMLA case that we're handling right now. It's a very common situation. Our client worked for a very large employer, retail, and the client, in order to get FMLA, had to apply through, the employer had what's called a third-party administrator. What that means is the client has to interact only with the third-party administrator to get FMLA leave. The employer is generally not involved. But here's what happens. We see it all the time. The right hand doesn't talk to the left. So the client applied for FMLA through the third-party administrator. It was approved by the third-party administrator, but the third-party administrator and the employer didn't talk to one another. So after our client, thinking they're out on approved medical leave for 8 weeks, gets a letter from the employer saying they're fired, we reach out and say, what are you doing? Here's the approval letter. And the employer said, because they never received notice from the third-party administrator, that they were going to uphold the termination. Well, we filed suit immediately on that case. Not a chance we're allowing that to go down. So we filed suit, we get into some discovery, and as it turns out, the law is in our client's favor. It says that if the employer is going to require a third-party agency to make decisions on FMLA leave, they're bound by those decisions. So that to us was a very simple case. We were shocked that they wanted to fight it, but we were able to secure approximately 1.5 years of wages for our client, as well as they paid our attorney's fees, not the client, meaning the employer paid our attorney's fees separately. And again, you know, a situation like that, when the client has a medical issue, it's really scary. But you know what's even scarier? When you don't have a job or insurance benefits because your employer did something illegal. So we were able to really bring comfort to that employee and our other clients who in FMLA type situations are scared out of their minds that not only do they not know what's going to go on with their health, but they are in fear of either losing their homes or not being able to pay their bills, losing their cars, and we bring some comfort to them. There's nothing more rewarding than for us to hear a situation where we're able to help a client who needs FMLA and get them some peace of mind that during their recovery for their medical condition or their wife's medical condition, or when they have their first kid, you're entitled to time off. If your wife gives birth, you're entitled to 12 weeks, assuming they're FMLA covered. To see the peace of mind that we're able to give to our clients in that type of situation is very rewarding. So we fight very hard on FMLA cases. We take them very regularly. You'd be amazed how many violations of the FMLA occur on a daily basis in workplaces throughout Florida and the country. So these are the types of cases that we handle. If you want us to take a look, it's always a free evaluation, free consultation. We'll get some information from you. We'll look at your FMLA documents. We'll analyze your situation. And we're straight shooters. If we think you've got a case, we're going to tell you you've got a case, and we're going to try to help you. If there's not a case, we're at least going to give you some advice. We might send you over to the EEOC to file a charge of discrimination if we can't help, if we don't think there's a case, to at least feel that you've been heard. But I would always err on the side of caution. If you're not sure what they're doing is illegal, send it to us. Let us take a look, and we'll give you some guidance one way or the other on our dime. So thanks for listening, guys, and have a great day. Hi, this is Richard Seller from www.floridaovertimelawyer.com. If you're a Florida employee and you feel your rights have been violated, reach out to our law firm, either toll-free at 866-344-9243 or at www.floridaovertimelawyer.com. I personally evaluate every claim that comes in, and I will give you the advice whether we think we can help you or not on your claims. Also, if you're outside the state of Florida, we handle cases all over the country. So go ahead and give us a call or an email and let us know how we can help, and you'll get candid advice from a candid lawyer about what to do with your claims.